Well, hello everybody. It is 12:02, so I think we're going to go ahead and get started here. Um, Thank you for joining us. My name is Troy Baker. I'm the Vice President of Community Relations and Educational Foundation here at the Better Business Bureau. Part of our mission here at the BBB is to help businesses thrive, and we believe providing educational opportunities like today are key. As part of our Trust Lab speaker series, we've invited a group of local experts to talk to you about advertising review, how to be honest and compliant with your advertising, and how to avoid those pitfalls, especially legal pitfalls, that are there with how you advertise your business. We're honored to have some experts here today to share their experiences with you. Before we get started, a little bit of housekeeping. We will be taking questions at the end. Everybody here is muted, so please type your questions into the chat and we'll get to them at the end of the presentation. I do want to tell you we will send out an email afterward that'll have a copy of the video and contacts for our presenters as well, so you have a way to get a hold of everything you need and the resources that we talk about today. With that, I'd like to thank our panel, Catherine Bennett, an Assistant Attorney General and Section Head at the Michigan Department of Attorney General in the Corporate Oversight Division. She'll talk about laws and what you can and can't do, and how the Attorney General's office is looking at things, specifically the Michigan Consumer Protection Act. I'll be speaking on behalf of the BBB, talking about our ad review program and what our process looks like and the rules about advertising review with the Better Business Bureau. And then Terry Chrisman is our Vice President of Operations. She's been at the Better Business Bureau a long time and knows all the rules and this program inside and out. And she'll be here to answer any questions specifically about the Better Business Bureau side. So with that, I will start with Catherine and hand it over to you.
Well, hello everyone. It's a pleasure to be with you today. Thank you for that introduction, Troy. As Troy stated, my name is Catherine Bennett. I'm an Assistant Attorney General with the Michigan Attorney General's office. I've been with the office for about 12 and a half years, and about the last 7.5 years, I've been handling consumer protection issues. So I hope that this is an informative presentation for you. Specifically, I'll be looking at the Consumer Protections Act's regulations as it pertains to advertising. Attorneys, we love disclaimers, so I have to make a disclaimer. Statements made in this presentation are not my own statements. They're not intended to reflect the views, opinions, or positions of the Michigan Attorney General or the Michigan Department of Attorney General. Next slide, please. So the Michigan Consumer Protection Act, sometimes we refer to that as the MCPA, is found in the Michigan compiled laws at MCL 445.901 and following. The law is primarily enforced by the Michigan Department of Attorney General. Sometimes a local prosecutor's office could enforce it as well, but primarily it's enforced by our office. It's a large and comprehensive act. I'm not going to be able to cover all of it today, but hopefully I will focus on some issues that are relevant to the crowd today. So specifically, the act regulates trade or commerce. And trade or commerce is defined in the act, and here in the slide, you'll see the definition. I won't read the whole thing, but the key here is providing goods, property, or services primarily for personal, family, or household purposes. So we're looking really at, consumers in their personal capacity, purchasing goods, property, or services. It does not include the purchase or sale of a franchise. It does include a pyramid promotional scheme. Next slide, please. So in trade or commerce, the act states that in trade or commerce, there are certain unfair, unconscionable, or deceptive methods, acts, or practices that are prohibited in trade or commerce. And I'm not going to go over all of those deceptive methods, acts, or practices today, but we'll talk about a few of them in particular. So one that we see a lot of is suggesting that a business is approved or accredited when it's not. The act prohibits causing a probability of confusion or misunderstanding as to the source, sponsorship, approval, or certifications of goods and services. Also, it's unlawful to represent that goods or services have sponsorship, approval, characteristics, ingredients, uses, benefits, or quantities that they do not have. The full provisions are there in the slides, but what we're talking about there is, for example, a business that puts on their website or on advertisements that they have a A+ BBB rating and that they're accredited by the BBB when that is not the case. Another example, you'll see here on the slide, like a stamp that says laboratory accreditation certified. We had a case where that came up where a business had put that on their website. In that there is a specific laboratory accreditation process that stamp is associated with, and the business did not have that accreditation. So that would be a prohibited practice to suggest that you have that accreditation or that approval or affiliation when you do not. Next slide, please. Kind of related to this is the idea of reviews that are falsified. And I have a few examples of this here. You know, a lot of times we get complaints about a business, the consumer read all the reviews on the website and it sounded stellar, it sounded wonderful. As it turns out, the business had a lot of issues and they were not true types of reviews. And so I give some examples of that there. That could also be arguably a prohibited practice under the MCPA. Next slide, please. So another one that we see quite often is using deceptive representations or deceptive designations of geographic origin in connection with goods or services. I think this is kind of a hot topic in society today. There's a lot of consumers that are looking for goods that are made in the USA. And I have an example here from a website. You can read all the language there, but you'll see you know, a suggestion that it's our mission to print and produce all of our products in-house right in the USA. And goes on to talk about, you know, how that's done. If the business is not indeed doing that, if they are actually selling goods that were created, designed overseas, that would be a deceptive practice under the MCPA to suggest on their website or in their advertisements that they are making it in the USA when they are not. Next slide, please. So a lot of what I've been talking about today, I've been talking about on businesses' websites. Of course, in today's day and age, why we still, you know, get complaints in our office about in-person sales. I'd say probably the bulk of our complaints we get from consumers pertain to sales advertisements online, whether that's on a website or on some sort of social media. And so the goods purchased would have to be mailed. And so it's important to note that a business should not advertise or represent goods or services with an intent not to dispose of those goods or services as advertised or represented. Representing or implying that the subject of a consumer transaction will be provided promptly or at a specified time or within a reasonable time if the merchant knows or has reason to know it will not be so provided is also a deceptive practice under the MCPA. So don't overpromise, you know. Sometimes, you know, mail service, delivery service can be a little bit slow. And if there's any reason why there's a belief that it's not going to make it there promptly, such representations should not be made. Next slide, please. And so this is an example from social media. As like I pointed out, we're not just talking about advertisements on the business's websites, but advertisements that the business might have anywhere. And social media is obviously a big place for advertising nowadays. And you'll see here consumers complaining on here. I ordered a product months ago. You're not responding to my emails. I've never received it. And so, if it sometimes delays happen. I guess there really should be an open line with the consumer if there's going to be a delay to avoid engaging in this type of deceptive business practice. Next slide, please. So coercion and duress. So it is a deceptive business practice under the MCPA to cause coercion and duress as the result of the time and nature of a sales presentation. And we saw a lot of this come up during the COVID pandemic. And I have an example of that in my next slide. So you'll see in this next slide, it's an advertisement regarding masks, which were obviously a hot commodity during the COVID pandemic. And you'll see, some of the language here, causing coercion or duress. We don't know how long we're going to have the masks. We could be ordered to ship them elsewhere, overseas. You're not going to be able to find them anywhere else, limited quantity, and basically preying on consumers' fears regarding, the virus and the need to protect themselves from it. And so that sort of coercion and duress is what we're talking about when we look at that deceptive practice. Next slide, please. So another important advertising regulation found in the Consumer Protection Act would apply to oral representations. So let's take ourselves out of the online internet sphere that we've been talking about and talk about in-person sales. There should not be gross discrepancies between the oral representations of the seller and the written agreement covering the same transaction. So if the seller is making oral representations about the product or the sale, the terms of it, you can't just correct that by entering into a contract or sales agreement that is inconsistent with those oral representations. The two need to be consistent. Next slide, please. And so as an example of that, I want to talk about an act that is related to the Consumer Protection Act, the Home Solicitation Sales Act. And that's found at Michigan Compiled Laws 445.911 and following. That act really works hand in hand with the Consumer Protection Act because it talks about door-to-door home sales, and there are some specific laws or rules related to that type of sale. Again, under the Consumer Protection Act, the door-to-door salesman can't be saying something different than what's in the written sales contract that the consumer will eventually enter into with the business. But the Home Solicitation Sales Act kind of goes above and beyond that. And I'm not going to have time today to go into all the details of that, but the main point is that there's a 3-day window where a consumer can cancel the contract and get a full refund. Again, this is only if the sale was, in person and falls under this act. And so in this situation, if you had door-to-door sales, even if you provide some services day of, if the consumers cancel within that window, they get a full refund. And I have an example here from one of my cases. Well, you'll see it says, kind of near the middle of this block. However, I acknowledge that if I cancel this agreement within the 3-day period after the initial service has been performed, the cost of my initial service will not be refunded. So that would be contrary to the Home Solicitation Sales Act. And again, if the sales rep were to say to the consumer before they hand them this contract, oh, we'll give you a free refund if or we'll refund you if you cancel in 3 days, or no obligation, that sort of thing, that would be an issue under the Consumer Protection Act, where the oral representations aren't matching up with the contract. Next slide, please. So a more recent addition to the Consumer Protection Act, it was an amendment just a couple of years back, involves impersonating the government. And this provision is found at 445.903M. The gist of it is this: if your business is not associated with a governmental entity, you should not represent, imply, or reasonably cause confusion that it's associated with the government or authorized by the government. Likewise, you shouldn't use government symbols, logos, or names. And here's an example here, and this is actually something that our office received because our office had registered a trademark with the U.S. Patent and Trademark Office. So this example wouldn't specifically apply. The Consumer Protection Act wouldn't specifically apply here because it involves impersonating a federal governmental entity instead of a state governmental entity. But I still thought it was a kind of a good example of what I'm talking about here. So this is a business that sends out to, they somehow get a list of folks that have some sort of government benefit. Here it was a trademark registration, and they're basically telling the consumer, your trademark's going to expire, it's due soon. They're looking to basically renew the trademark for the consumer and somehow benefit financially from that. There is some small print on there, where they do disclose that they're not actually the U.S. Patent and Trademark Office, but it does cause it could cause confusion for a consumer because unless you're reading the real fine print, you're thinking that this is the government telling you that you need to renew, and it's not the government at all. So that's the type of thing that we're talking about with that provision. And again, it's a newer provision within the Consumer Protection Act, but it's something to look out for. Now, just to talk briefly about the Attorney General's role, we receive complaints from consumers, and oftentimes we will mediate those. So we would forward the consumer's complaint to the business and ask for them to respond and copy us. Most of the time, we're able to resolve issues that way. Sometimes we see patterns of complaints, or we have complaints that are not resolved through mediation. And at the Attorney General's option, we may either pursue litigation or a civil investigation under the Consumer Protection Act. This provision that's up on the screen on this slide describes the civil investigations that we conduct. Basically, we go to the court ex parte. What that means, that Latin legal term means, is that we can go to the court without giving notice to the business. We explain to the court why we want to investigate these business practices, the complaints that we've received or the information that we've received. And if we show probable cause to believe that the person is engaging, or is about to engage in a deceptive business practice under the MCPA, the court will issue us an order allowing us to conduct this investigation. And basically what we do then is issue subpoenas to either take investigative testimony, which is like a deposition, or to get records from the person accused of engaging in these unlawful activities. And it moves on from there. Next slide, please. So in terms of notice. So if the AG, I talked about just now the investigation portion, how we can go to the court without giving notice to the bad actor. Um, in the situation of litigation, if we're going to file a lawsuit under the Consumer Protection Act, we do have to provide 10 days notice. We do that through what's called a notice of intended action. And it gives the business an opportunity to cease and desist. And through that, we are seeking assurances that the business is going to comply with the law moving forward. Next slide, please. So this is an example of not the complete notice of intended action, but one that was issued just a few years back. It involved a toy company in Western Michigan that we had received complaints about, that they were taking orders and not fulfilling the orders, and we were approaching the holiday season, and so we sent this notice of intended action to the business, asked them to immediately cease and desist from engaging in the unlawful business practices, and we quoted the Grinch there, given the timing of things. In terms of a notice of intended action, usually, I don't want to say usually, but oftentimes we are able to resolve any disagreements through this process. The business reaches out to us within the 10-day period, and we are able to talk through. There's a provision in the Consumer Protection Act that allows for the business to provide formal assurance of voluntary compliance to our office, which is typically, it looks like a settlement agreement, basically, where the business will agree to comply with the law moving forward, stop any unlawful business practices, and then sometimes it might include compensating consumers or providing consumers refunds if that's been implicated by our investigation. So oftentimes that's how these matters are resolved, rather than going forward with litigation. Next slide, please. In terms of litigation, there on this slide, you'll see the two key provisions in the Act regarding that. The first one, in Section 5, involves basically as injunctive relief. And for those not familiar with that legal term, it means that we'd be going to the court and asking the court to order the person to stop what they're doing. You can't do this anymore. It's contrary to the law. The second one, in Section 10, talks about a class action for actual damages. That would be when we are looking to get damages, actually money, for consumers who've been wronged by the unlawful conduct. And so I hope that was a helpful overview. I did not mention as part of my disclaimer, and so I want to throw that in here, that this should not be construed as legal advice. Obviously, our office cannot be providing legal advice to businesses, but I do hope that it was helpful and informative for you today. And I know there's going to be an opportunity here at some point before we conclude to ask questions. And I thank you for your time.
Yeah, thank you. And I will reiterate, if you do have questions for Catherine, go ahead and put them in the chat or the Q&A, and we will get to them at the end here. We really do appreciate the partnership that we've grown with the Attorney General's office, and the Better Business Bureau has been working on advertising standards for a very long time, and we're going to talk a little bit about what those rules are and how we implement this, because we know if you follow our rules, you are very likely not to run afoul of the legal side of things that Catherine had talked about here. So Let's talk a little bit about Better Business Bureau itself. You may not know the Better Business Bureau itself was founded in large part to combat false advertising. Founded as businesses came together to create an organization that would set standards for businesses and help enforce those standards. And one of the things our team does is advertising review. Every business that seeks to be BBB accredited goes through this review process. We make sure that your advertising is following our rules. We review BBB accredited businesses regularly to make sure they're staying up on those rules. And then any advertising we come across that's reported to us with potential concerns. So if you see an ad that you see out there that you think is problematic, send it to us. We can review that and hopefully, get them to change it if there is a problem there. I will say our code of advertising is very thorough. 39 points of emphasis, many with several subpoints within that. There is a lot there that we go over, but it is how we hold businesses to that higher standard of trust and ethics, and it promotes honest and ethical practices within our marketplace. So that's the first thing we want to promote a trustworthy marketplace. I will know our guidelines, our recommendations. We are a nonprofit entity. I can't force a business to take any specific action. That is why we have the partnership with the Attorney General's office and other organizations. If it falls into that legal realm, we can hand that off to our partners who can take that further action. And we work with Catherine, the Attorney General's office, very regularly on cases that we come across. But I can't force them as a nonprofit. But what I can do is share that information publicly. So if you are being dishonest within your advertising and we go through our review and you don't make those changes that we feel are necessary, we're going to add that to your business profile for every customer that comes and looks you up to see this company may not be honest with you. This company may be an issue. And if you're an accredited business and you've got these issues, we will revoke your accreditation. We're not going to let you be accredited if you're not going to follow those rules and operate with trust and ethics. And I will know our standards closely mirror Federal Trade Commission rules, and there's a good reason for that. The Federal Trade Commission actually took their first advertising rules and standards from the Better Business Bureau many years ago before I was involved in this. But there's a reason those standards look very similar. It's because we were the source that they originally went to start this up. So there's a lot of background there and a lot of heft to what we have done over the years and why this is important. So let's talk about some of this, and we're not going to get into all of these, but I will say from a business standpoint, a lot of this comes down to transparency. And be prepared to substantiate the claims that you're advertising you're making. You should be able to back up what you say and really make sure that that's good. Most problems and complaints that we see at the Better Business Bureau can be tracked back to expectation setting, making sure you and your customers are on the same page. And that's where a lot of this substantiation and transparency comes into play. If the customer knows what to expect and how it's going to work, they are less likely to have a complaint down the road because both of you are thinking the same thing and have those same expectations. So the more you can do as a business within your advertising to be honest and upfront and transparent, the less problems you're going to have with your customers down the road when they thought it was going to be something different. So some key elements of our ad review standards. Part of this is avoiding exaggeration and misleading statements. Catherine talked about some of these misleading statements and misleading consumers. We talk a lot about that too, but even from a more nitty-gritty standpoint, one example on here, the #1 new cars sales in the city. You should be able to show that there is data backing that up. You just can't say you're #1 if you don't have some sort of data to back that up. And avoiding those bait and switch situations, luring people in with a very low, this big discount that's very low price that they're never going to qualify for. We had a situation about a year or so ago. There was a duct cleaning company advertising whole home duct cleaning for very cheap. It was something like $100 or something. But when those people showed up to do the duct cleaning, nobody ever qualified for that discount because there was always something else going on. They found mold, they found this, they found that. It was all a bait and switch. And that's where customers get upset because you're drawing them in under false pretenses. Um, Businesses lose their reputation, and in some cases, it ends up in the legal realm where you have violated the law and could end up in trouble that way. So, making sure that when you are making offers, when you are doing that, you're being honest about what people are going to get and that it is reasonable. When we talk about pricing and being clear, be clear about your pricing. Um, People who say we're the lowest price in town, be ready to substantiate that because from a Better Business Bureau standpoint, we're going to ask, show us where that you've proven that out. Be clear about price matching. If you say your company matches your competitor's pricing, be honest about that. Be clear about what those terms are, and don't have any unrealistic exceptions to that rule. Put yourself in the customer's shoes. If you saw that advertisement for a business and they said we match our competitors' prices, what would you expect that to be? That's a great rule for you to figure out if you're meeting that expectation and preventing those issues. And then the idea of sales. These should be short-term price changes. I think we've all heard the stories about the going out of business sale that never ends. A year later, that company's still there with those same prices. Those aren't a sale. You don't operate about that. Really is kind of a bait and switch type thing. So making sure that the sales that you're offering really are sale prices, and they're meant to be a short-term discount and then move on with that. One thing we look a lot at right now and is great for all businesses to think about is data privacy. We talked in our previous webinar about cybersecurity and data and what happens. As a business, you have a lot of data that you are collecting on your customers. So how are you using that? Make sure that you are very clear with your customers with a privacy policy about what you are collecting, how you are collecting it, and how it is being used. There are a lot of rules and a lot more rules year in and year out about how this happens, and that will continue to evolve. So make sure that your business is protected by having good policies in place and having a good privacy policy that lists out things. So what should, from a BBB standpoint, your data privacy policy standard look like? Well, from a Better Business Bureau standard, we require your privacy policy to list out what information is collected, how it is used, with whom it is shared, how it can be corrected, how it's secured, how your policy changes will be communicated, and how to address concerns over the misuse of personal data. These are all standards that we require. Now, good news for businesses, we have some draft options for you that you can look at and kind of help you build out the policy that works best for you. You're not on your own to just figure this out on your own. We can help with that, but it really is something that you need to pay attention to as a business because rules regarding this are changing year in and year out. Another thing that we look at is our name and logo policy. As Catherine says, you can't say that you're BBB accredited if you're not. You can't say that you're A+ rated if you're not A+ rated. So there are lots of reasons if you're BBB accredited to use those logos and share that out because it does make a difference. One of the great options we have for you is that dynamic seal. And if you're BBB accredited, talk to your regional account manager. They can help you get that code to put that on your website. It keeps everything updated. It's interactive. So when you hover over it, it shows that you are A+ rated, but it's got the BBB logo on there when you're not hovering over it. Really is kind of a great way to make sure you've got everything that is up to date and compliant. Some things that we see a lot of. There are logos that are used by the Better Business Bureau, but shouldn't be used by businesses. So these logos right here, the BBB with a little torch on it, the sign of a Better Business campaign, those are for BBB's use, not for businesses. If you are a business, you should be using these logos. The accredited business seal or a charity, an accredited charity seal. There is also a black and white version that would say accredited business under it for certain print operations that won't allow the business seal. But again, don't just make up your own thing. Make sure that you're talking to your account manager and using the right logo. Don't change the logo. Don't go to Google and just find whatever you want. Use the right ones. That way you're using ones that everybody recognizes. It looks right, it fits right, it operates correctly. One of the things Catherine mentioned is, some of the legal side of things. And what we have found, and you will find with our trademark and any other trademark that is out there, if you misuse it, you are in for some problems, usually civil problems. So we have a number of trademarks with the Better Business Bureau, different sayings that are trademarked that some businesses can use in certain places with permission. So again, that goes back to talking to your account manager and getting permission ahead of time, because there is a process for businesses that do it wrong. And while legal option is one of them, there is one that we use fairly regularly that you won't like if you're in the violation of this. We try to work it out for you. First and foremost, if we find a problem, we try to work it out with you. If you're using a logo and you shouldn't be, we ask you to do it right. We'll do that a couple times. We'll try to get it worked out. If not, we send it to the lawyers at the International Association of Better Business Bureaus, and they're going to try to work it out with you. If that doesn't work, they have the right to file a lawsuit, but there is an easier solution that businesses do not like. They file a trademark violation with your service provider of your website, and your website gets taken down. If you're using our logo or our trademarks illegally, the website just disappears one day. And that's how we take care of you using the logos on the website wrong, is we just get your website taken down. And you have to go through the time and expense of rebuilding your website and putting it back up because you violated somebody's trademark. We have the ability to do that. Anybody else that has a trademark has the ability to do that. And it's happening much more frequently. So when you are using information, especially if it's somebody else's trademark, make sure you've got the right permissions for it. That means from a business standpoint, don't just trust the website guy that you hired or the company to build a website. There are people out there that say, these logos look good. Let's put them on there. It makes us look better. If you don't have those certifications, if you haven't won those awards, if you don't have the rights to use those logos, you may just lose your website because you violated their trademarks. We have a team here that does a lot of advertising review and helps businesses work through problems. And that is really, we talk about the bad side of it, but we really are here to work with you and try to resolve it. We're not going to take any drastic action until we've given you a chance to correct things and make it right. So there are resources available, our website with our code of advertising and our accreditation standards, and our contacts here at the Better Business Bureau to help out. So with that, I'm going to bring in Katie and remind everybody we do have some Q&A time and questions. Katie, do we have any questions coming in yet?
Not yet.
All right. So I do have one that I do want to ask Catherine to touch on a little bit, because it's something we've talked about a little bit, and we are coming into the holiday season. And one of the things we will be talking about a lot is online shopping and drop shipping websites. And one of the issues we have seen, these are websites that don't actually have the product. They create a website and they buy it from overseas and have it shipped directly to you. They're just a middleman. But the thing that we see is a website that says, here's a $150 product on sale for $10. They buy it for $2. It's never been $150. So the question that we often hear is, where is that line between, a reasonable markup and just lying to people about the value of the product they're trying to sell?
Sure. So, drop shipping in and of itself is not illegal under Michigan law, but there are a lot of issues associated with it. Our office has a helpful consumer alert available online on this subject, and it actually includes some warnings, not just to consumers, but also to individuals that are thinking about engaging in drop shipping, because um, you know, as a seller, you're not going to have any control as to when that third party business fulfills the order, which can cause some issues. As I was speaking about, you can't promise that you're going to promptly deliver or promptly send out a goods that are purchased, and then if you have reason to believe that they're not going to make it there promptly, and if you are submitting the order to a third party overseas that sometimes takes weeks and weeks and weeks to send it out, that causes some issues there. Specific to the pricing of it, there are provision in the Consumer Protection Act that I didn't talk today, talking about charging a grossly excessive price that could be applicable in that instance.
Thank you. I know that is one we get as more and more people go into this and trying to figure out, what is a reasonable markup and what is the, just deceptive. I'm trying to make it look like I got a great deal on it. Terry, one question that we get a lot from businesses has to do with return policies and warranties. Would you talk a little bit about how that's handled within the ad review process?
Sure. Currently, and Catherine, you'd be able to, correct me on this if I'm wrong, but it's my understanding that in Michigan, companies are allowed to set their own refund and return policies, and it's up to the consumer to inquire what those are at the time they make a purchase. So if somebody's in store making a purchase, many companies do have their policies posted, but it's my understanding it's not required to be. So it's really up to the consumer to find out about that. But as far as companies selling products online, there are requirements about what needs to be listed. And we do ask that companies that are accredited, if they are selling products online, that they clearly disclose their refund policy. So consumers will know at the time they're making the purchase what that is, if they can't even return it. Companies are not required to even accept returns. So we recommend, again, companies that are accredited, that's one of the accreditation standards, if they're selling products, refund policy be posted. If they're not accredited or they're not selling products online, it's not required to be posted, but we encourage it. And then as a consumer, we always encourage consumers to find out about refunds and returns before they make that purchase. That's probably our number one complaint call around the holiday times, are people who make purchases and then later find it cheaper somewhere else because they didn't shop around, and then they're upset because they can't return the item. So that's really a timely topic right now. So please, if you do have a return policy, or even if you don't accept returns, post it. The more information you can provide your consumers or arm your consumers with, that's a win-win. It's good for the consumer, then it's good for you too after the fact.
Terry, the other thing our team finds a lot of as we review businesses, especially websites, are satisfaction guarantees. Talk a little bit about the satisfaction guarantees, 100% satisfaction guaranteed, and our advice to businesses who really want to advertise that type of thing.
Sure, thank you. So that's a great point. In BBB terms, if a company is advertising a satisfaction guarantee or 100% satisfaction guarantee, things like that, that means or we expect that company to refund the consumer's money in full if they're dissatisfied. So if companies are advertising that, as long as they're prepared to do that, they can advertise that way. If they're not prepared to do that, then we recommend they change their verbiage slightly. We strive for your satisfaction. We try to make all our customers happy, whatever it is. But if you actually say satisfaction guaranteed or 100%, satisfaction, words like that, then according to the BBB Code of Advertising, the company would be required to refund the consumer's money in full for any reason if they're dissatisfied. So we just want to make sure people are aware of that. And again, that's one of our accreditation standards. If the company is an accredited business and we receive a report about that, like you mentioned, the name logo issue, we first contact the company, try to get them to work with us with that consumer complaint to honor that. And then if they refuse to do so, that would be a violation of our accreditation standards and the company would be revoked for that. And that would be reported as well. So, unless you really mean it and you're prepared to refund your customers' money, use something else other than satisfaction guarantee.
We have a question. Go
Sure.
ahead. We have a question from online. Do you have any advice for balancing providing the correct amount of information to the consumers and providing information consumers will actually read, especially in ad mediums with limited space?
That's a great question. A refund policy can be added like in the footer. And most consumers, especially those that shop online regularly, are fairly savvy and oftentimes will look for that policy. They're looking for the shipping policy, looking for the refund policy, looking for those kind of things. So if you have it posted somewhere on your website in your footer possibly, at least you're covering yourself and the consumer can seek that out. That would be online. And it is a fine line because you do have a limited space and you want to try to get as much information as you can to your consumer. So the privacy policy, if you're collecting any kind of personal information online, the privacy policy is a must. And as Troy mentioned, we do require the 7 components there. So that's very important to have posted. And again, that typically is going to be in your footer. So the consumer can access it at any time. Your refund and return policy should be listed as a link in your footer as well. Another thing that we recommend, and Troy mentioned this too, is guarantees and warranties. We do see a lot of issues with companies claiming or advertising their guarantee or warranty. The Code of Advertising requires that if an accredited business is advertising a warranty or guarantee, they need to list the terms. They need to either list the terms in the ad so consumers again know how to access a warranty or guarantee for that product, or include some kind of disclaimer that says ask us for details or full warranty available upon a request or something like that. And again, that can be in your footer. So it's on every page, so you don't have to worry about it. If you don't care to put it in your footer and have it on every page, then it's highly recommended that warranty, either disclaimer or explanation, needs to appear in close proximity wherever the word guarantee or warranty is used. Again, so that consumer will know what's involved with that and how they can obtain service if they need to.
And I think, and for both of you here, is there an issue with the asterisk, see us for terms and conditions?
Catherine, you want to go first?
Sure. So if you look at a lot of the language in the MCPA, it talks about like a probability of creating confusion or being misleading. So I think I gave the example of the newer provision regarding being associated with a government entity. If you make some suggestion that your business is authorized by the government or doing something on behalf of the government, and the consumer has to navigate down the sub menus to 3 different pages to find a disclaimer in tiny font, size 8 font. Actually, we're not authorized by the government. That's arguably misleading or causing a probability of confusion. And I think that could apply to a lot of different statements in your advertising. Obviously you can't have everything up top and in large font, but if you've got a disclaimer that seriously steps back from your representation, it shouldn't be buried and basically impossible for a consumer to locate.
So if you've got an advertisement that says this service for this price, see us for terms and conditions, or ask us for terms and conditions, and you're reasonably offering that, and there's a couple of things, but you don't want to get all the fine print in there, that's probably okay. if you've built something out that there's so many exceptions, nobody's going to ever get that price, that's probably problematic. So it's kind of how much heavy lifting you're giving that asterisk.
Yeah, anything, I concur with exactly what Catherine said. If it's something that's going to seriously affect the customer's interaction or that purchase, it needs to be, our policy says clear and conspicuous. So that's open to interpretation, but it's not buried on page 3 and 8.5. I know exactly what she's talking about because we've seen that too. So again, if there are requirements or terms and conditions that need to be met in order for the consumer to take advantage of whatever the offer is, it's being advertised, that needs to be clear and conspicuous. For our purposes, we believe that it should be on the same page, the same screen, the same page. So the consumer is seeing the offer, they're seeing the terms and conditions at the same time, rather than having to go pages down to find it. I also want to mention that one service that we do provide here is, if a company is revising their website or they have any questions about about advertising or anything else really, they can send it to us. We can review it. We can provide them with tips or suggestions. One thing we didn't mention, and it wasn't in the presentation either, and that is companies that offer financing. So there's a whole slew of requirements if the companies list triggering terms. So there are some specific triggering terms, the FTC Truth in Lending Act, but if those are used, then they require certain disclaimers. So if you're doing any kind of financing, I would encourage you to contact your regional account manager or contact your office directly. We can get you in touch with our ad review team, and we can help make sure that you have the required disclosures if you are doing any kind of financing.
And I think that's the key point here is that we are a resource to help you make sure that you're following the rules. And if you can follow our rules, the odds are very good you're following Catherine, the Attorney General's rules, and the Federal Trade Commission's rules as well. I never say 100%. There's always, somebody's going to slip through at some point. But if you can meet our standards, you are probably going to meet all those other legal standards as well, if you're doing things right with the best of intent. So thank you to Catherine Bennett from the Michigan Attorney General's office, Terry Chrisman from the Better Business Bureau. We appreciate you joining us. We will send this out. If you have any additional questions, feel free to reach out to our office. We are happy to help as a resource to make this a better marketplace and better businesses.